Back now to the breaking news that is our top story right now. A federal appeals court ruling that President Obama violated the Constitution when he sidestepped the Senate and filled open positions on the National Labor Relations Board. The ruling that raises questions about hundreds of decisions issued by that board, most of which have been very pro-labor for more than a year now. Do those stand? Are they void? Are they thrown out? Who's on the NLRB right now? Can it even adjudicate anything? Lots of questions right now. We're going to get answers. Jay Sekulow is the chief counsel for the American Center for Law and Justice. He is also one of the attorneys, one of the victors in this case. He filed a friend of the court brief on the case, arguing that the administration had violated the Constitution. And Julian Epstein is a former chief counsel for the House Judiciary Committee and former staff director of the House Government Reform Committee. Gentlemen, welcome back. Wow, so this was a unanimous decision. I guess congratulations to you, Jay, are in order since you had a hand in this. Can I think a lot of our viewers sort of know, okay, NLRB, they adjudicate disputes between companies and labor, but explain the significance of this ruling.
Well, you actually said the significance in that in the beginning of your introduction to this issue, and that is these decisions that have been made by the NLRB since these appointments that the president made, these so-called recess appointments that the three-judge panel has now ruled invalid from their inception, which means there was not a quorum of the NLRB, and those decisions are null and void and of no effect. And
there's normally 5 members on the NLRB, right? There's normally 5 members,
right.
And he put 3 people on,
right.
two men and a woman, and now the court's, it's as if they were never there for this past year.
That's right. The court said right from the beginning, from its inception, those appointments were basically unconstitutional. And we represent the Speaker, John Boehner, in this case. And I'll tell you, I think this is a great win for the Constitution and the separation of powers. I know my friend Julian's going to disagree, but I think this is a very important signal that the president is a president. He's not a monarch. He doesn't get to make these decisions by himself. There's a reason we have advice and consent in the Constitution. And I think this was a big day. No doubt about it.
Julian, your thoughts?
Well, if Jay wants to say this is the decision of a monarch, then he would characterize former President Bush as a monarch. Former President Bush made somewhere in the order of about 171 of these appointments. These are appointments that have regularly been made by presidents. President Clinton made 139. And what the court said here, which is different from what other courts have said, is that presidents cannot make recess appointments unless we are 1 between Congresses or 2 between sessions of Congresses, which occur at basically the end of the year for a very short period of time. Presidents, since we have all known about, since we can remember, have made recess appointments on things like summer recesses when Congress goes away for the month of August. So what the court is now saying is their interpretation of the constitutional power to make recess appointments under the Constitution limits the president's ability to do it except for these very, very narrow time frames. And that is a rule that has never governed presidents.
There's no question that President Bush made a bunch of recess appointments, as many presidents have done.
Including one of your contributors, John Bolton.
However, there was a question here right from the very beginning about whether President Obama could do it under this particular recess. This was a unique thing, and the Senate pushed back almost immediately.
Right.
Explain that to us, Jay.
Well, it's because there was actually business being done. They call it pro forma, but there were bills introduced, panels set, actual legislation signed, including debt limits and increases in various commerce bills that came through. So the fact of the matter is the Congress was actually working here, Megyn. And, Julian likes to cite President Bush and these others, but let's look at what the Constitution says, which is what the court said here. Recess appointments for the first 100 years of our Constitution were rarely ever used by a president, and it was when the Congress was in the recess. And all the court did here was say what the Constitution says, which is when the court's in the recess, a recessed appointment can be made. When it's not, it's not. They weren't here.
Julian, you have been right on many predictions here in America Live, so I want to give you that up front. However,
yeah, he's done well on the
However, you were not right on this one. You came on and said, "I think there is no chance this will be thrown."
Well,
I don't
think that this case is over. I think this will be appealed to the Supreme Court, and
that doesn't mean they have to take it.
Chief Justice Roberts,
Yeah,
I think you will because you've got a conflict now. I think Chief Justice Roberts has asked a question to the Deputy Solicitor General in a previous case of why couldn't the President simply use the recess appointment for a case that's similar to this. To Jay's point, look, I mean, 100 years ago, we didn't have congressional schedules the way we did. And more importantly, this was a pro forma schedule during which President Obama made the appointment, and there was very little business going on. They were coming in for a minute or two each day.
But there was business going on.
The purpose for keeping these pro forma sessions was to prevent the President from making recess appointments. So again, what we're talking about is setting up, and the courts can do this, is setting up a new set of rules for President Obama that haven't applied to any president in the last 50 years.
Well, has there ever been a president who tried to do it when the Senate was in pro forma session, when they did have business going on? Was this a first? This was a first by President Obama.
Megan, that's exactly correct. The fact is, President Obama is the first one that did this while actual business was going on, where the House and Senate were not in recess, a recess or the recess. So that's the big difference here between those.
Look,
what does this mean? Hold on, because this is important. What does this mean right now? I mean, so if they appeal to the Supreme Court, and we'll have to wait to see if they take it, but even if they take it, then we have to wait for briefing and argument and so on. What does this mean right now, Jay? That are these decisions over the past year void? Like there have been some important decisions out of the NLRB over the last year.
Yeah, they're void. The three-judge panel of the U.S. Court of Appeals for the District of Columbia said the appointments were invalid from their outset, and that means the decisions made by them was not a quorum. The court addressed that issue. Those opinions and those decisions that came out from the NLRB, void. Period.
What does that mean now as a practical matter, Julian, for the companies out there and the unions who received rulings from this board? I mean, it's somewhat chaotic.
It means total chaos, and I would agree with Jay that it probably does mean they're void unless the Supreme Court in the appeal wants to stay that part of the D.C. Circuit decision, which they could. And look, you've got two former officials in the Bush Justice Department and the Office of Legal Counsel who have basically said that this pro forma session is it's a total artifice. It's an artifice intended to prevent the president from exercising his constitutional power in recess appointments. And these two former Bush officials basically backed up the legal position of the Obama administration when he said, look, when they said these artificial recesses that the Senate was taking, they were really not conducting any serious business. So in fact, they were recessed. So you're talking about something that's deep into the legal weeds here.
Go ahead, Jay.
That's right. They did say that was wrong.
The three-judge panel disagreed with everything Julian just said and everything the Obama administration said and everything
the Bush officials said.
All right, so
and everything the Bush officials said, and it's not necessarily the last word on this.
For now, the only thing that matters is what the court said, what the D.C. Circuit Court of Appeals said. Now we'll see.
Correct. But that may not be the last word.
That's right. That may not be the last. You won one, Jay.
Finally, Jay gets one.
Yes,
note it for the record
Julian's
books.
Listen, he's got the count going in his favor. This was nice for a change.
Great debate, you guys. Congratulations, Jay. Good to see you both.
Thanks.
Thank you, Megan.
All right, coming up.